And so it's a pleasure to welcome Patrick McGahan. He's a private partner of Scott & Scott Attorney at Law in Connecticut and London offices and works closely with other members of the firm's antitrust and competition practices in counseling corporate and institutional clients, evaluating potential claims, and developing strategies to recover losses caused by anti-competitive conduct. He's an anti-competitive antitrust expert, and he's a strong focus on consolidation and the impact of anti-competitive conduct in agricultural industries. He is presently co-lead counsel in the cattle and beef antitrust litigation that you initiated. He presently co-lead counsel and he's acting on your behalf for RCAF USA, as well as the National Farmers Union, who has joined in this case as a plaintiff, and he also acted for clients in a variety of securities litigation, arbitration, both investment treaty and commercial, and pieces of general commercial litigation. It's because of Patrick I have had to study Australian, the Australian language, and with that, we welcome you. Thank you, Patrick.
Cheers, Bill. As Bill said, I haven't been doing this as long as David, but I've been doing it for a while, so I appreciate coming back here. It's always great to come out to South Dakota. I brought my family this year. It's a beautiful country. We've had a great time. So today I want to give an update on the litigation, where we are, why it's taken so long, and the answer in short, a bit like Dave said, courts take time. What you can do to help. You might also recall that the DOJ, the USDA, and the state AGs are also investigating some of the same conduct. I'll give you a bit of an update about where they are. Talk about some other litigation in ag. Talk a little bit about what the current FTC and DOJ is doing in other industries, which I think is important for us to think about, and then take some questions. So, the litigation that we represent RCAF and NFU on is an allegation, concerns an allegation that the big four packers, Tyson, JBS, Cargill, and National Beef, worked together from in and around January of 2015 to suppress the price they paid to cattle feeders for fat cattle. Now, the allegation boils down to sort of two forms of conduct. The first is that they would reduce their kills collectively to limit the amount of cattle that they were purchasing, to put downward pressure on cattle prices. The second is that they would coordinate the manner in which they bought the cattle in the field. Since we filed that claim in 2019, it has ballooned into one of the largest antitrust cases in the country. It is presently proceeding before Judge Thunheim in Minnesota. In addition to our claim, there is a class claim on behalf of feeder cattle plaintiffs. There's also a class claim on behalf of the people who buy beef directly from the packers, the restaurants who buy the beef indirectly from those people, and on behalf of consumers. In addition to that, there is claims from about the 40 to 50 largest retailers and wholesalers in the country, like Cisco, Target, Kroger, also alleging that they were harmed by the same conduct that we laid out in our complaint. On the beef side of the fence, their argument is by reducing the amount of cattle that they were harvesting, the packers were reducing the amount of beef they were getting to the market, and this in turn raised the price of beef. So you have, before this one judge, the claims, the 6 class claims, and you have these 40 claims on behalf of these large retailers. And what that means is that this litigation moves slowly. There's a lot of people to push through. 2013 was largely consumed with document production. The defendants have produced about 700,000 documents, totaling in about 10 million pages. Third parties have produced about 500,000 documents, again totaling about, I think it's about 5 million to 6 million pages. So there's a lot of time spent reviewing those documents. We collectively on the plaintiff side have a team of about 60 attorneys reviewing those documents all day, every day, and feeding out information to the attorneys running the case. In late 2023, we began depositions. which is, in simple terms, witnesses are put in a chair, they're put under oath, and we get to ask questions. The rest of the year, we'll be continuing to take depositions. I'm taking a deposition of John Gerber, who used to be Tyson's VP of Procurement, on Wednesday. The plaintiffs themselves will also be deposed, and those will begin shortly as well. The other big thing that we have been doing is, a bit like David described, antitrust litigation is very heavy on expert evidence. The measure of antitrust damages are what price would you have received for your fat cattle but for the anti-competitive conduct? And what that boils down to is economic experts doing a study of how cattle prices behave and try to model what would have happened but for the anti-competitive conduct. So we have a set of highly qualified experts that will argue that it suppressed fat cattle prices. Defendants will line up their own set of qualified experts who will argue it did nothing at all. And we'll have a fight about that. So that is the other thing we're spending lots of time doing. The next major deadline that we have is our class certification motion, and that's due in September. And that's the motion where we lay out to the judge why we believe, under the federal rules, this case makes sense to proceed as a class action rather than a set of individual actions. Now, this used to be a very simple procedural step. Over the years, it has been turned into a very significant battleground in which all the defendants line up to try toss the case as a class case, because that drastically reduces their exposure. If they're only liable for the 4 or 5 named plaintiffs' damages versus the entire fat cattle industry, you can think about what that does to their risk exposure, right? It dramatically decreases it. So a lot of time and money is spent arguing whether or not this case should proceed on a class-wide basis. We are quietly confident that if we do the work right, and we are doing the work right, that we should get this motion through. Judge Thunheim, our judge, is also handling the pork antitrust case, which concerns similar allegations. It's a little bit ahead of us, and he recently upheld class certification in that case. And he laid out a pretty good roadmap for us to follow in terms of what we need to show for this judge to certify our class. Briefing on that is going to close early in next year. The judge will probably take a couple of months to rule on that. And in between that, we're going to continue taking depositions right the way through January 7th of next year, continuing, and that'll be both of parties, so defendant employees, plaintiff employees, and third parties. And then what happens after that is, assuming the judge rules in our favor on class cert, then there will be what's called a summary judgment motion, which is basically, the short answer to that is, the judge is asking, is there a question of fact that should go to a jury? So the defendants are going to put in papers that say there's absolutely no evidence that there was any collusion. Our opposition brief will lay out, look, here is the evidence we have. Here's why it should go to a jury. And that's the question for the judge. We only need one question of fact to get it in front of a jury. And then that's where it would head. So I mentioned a moment ago that there is a parallel suit on behalf of sellers of feeder cattle. We don't represent that class. They're represented by 2 other very able attorneys, Frank Guerrera and Rick Paul, some of whom you might know them. Their complaint was recently dismissed without prejudice on antitrust standing issues. So the judge didn't find that they hadn't pled a conspiracy. What he found was that on the facts that they had alleged in their complaint, they hadn't yet shown that they met the sort of technical legal criteria for standing. So they have an opportunity to amend. That's going to go in not next week, the week after. And I think the judge gave them a pretty clear roadmap for what they need to do to get that case back on file. And so I'm quietly confident they'll manage to do that. And so then you'll have 2 classes of cattle producers represented in this case. We're representing the folk that sold the fat cattle to the packer, and Rick Paul and Frank Guerrero will be representing those who sold feeder cattle to the feedlots. Those who have been here before will have seen this slide, but for those who haven't, we're often asked, what do I need to do to join a class? The answer is absolutely nothing. The way that class actions work in this country is you're all in the class until you decide to opt out. So what's going to happen is once the judge certifies a class, everybody who is presumptively in that class will get written notice of the fact, and they'll be given a time to opt out. Similarly, if a case goes to trial and is successful, or if there's a settlement, and there's sort of a shared damages pot for people to claim from, they will also get notice of that fact. And there'll be a simple claim form to fill out to ensure that you get your pro rata share of that money. What I would encourage you all to do, though, is to keep a record of your cattle sales from 2015 forward and any live cattle futures contracts you traded, so that when you come to fill out your claim form in the event that we're successful, you have a record of what cattle you sold and what contracts you traded. Should we go back? Sadly, unlike David, I can't yet give you a fly on the wall details of all the evidence we're seeing. There's a protective order in the matter which limits what I can discuss publicly in the same way that it limits the defendant's attorneys talking to their clients about, bills or the wine rice's private details. But what I can say is that we are happy with the way it's proceeding. We're seeing evidence come in that we think supports the theory of the case. As we depose more and more senior employees from the defendants who are likely to have been in the room when the relevant decisions were made, we're starting to get more and more of the evidence that we would like to see. That said, it's not going to be a pushover. These packers aren't idiots. They don't do things out in the open, so we're going to have to fight pretty hard to prove the case, but we're giving it a red hot crack. Government investigations. So you recall after the Holcomb fire and COVID, the USDA announced that it was investigating the packers, and it released a very short report in 2020, which it labeled a preliminary report, basically describing market conditions, which was lovely, but didn't really get at the core question. There was also reported publicly that the DOJ Civil Division sent CIDs, which are civil investigative demands, it's a subpoena, to the packers, and that they are investigating, and that various state AGs from basically all the major ag states were also investigating the packers. None of them have yet filed any suit, but we understand that all of their litigation is ongoing. We have some degree of cooperation with them. What we know for sure is that the cases have not been closed, because as soon as that happened, we would have the defendant's attorneys running to our court to tell the judge that the state AGs took a look and didn't find anything. That has not happened yet. There is a lot of other ag antitrust civil litigation going on at the moment. I won't bore you with all the details, but first of all, there is a pork antitrust case is before Judge Thunheim, as I said, which is our judge. That's getting to summary judgment just now. Like his class cert, we expect to learn a lot about what he's looking from his summary judgment opinion there. The broiler chicken case, you might have heard that there was a trial between the direct beef purchasers and Sanderson Farms up in Illinois end of last year. Unfortunately, the plaintiffs did not win that case. The jury found that they hadn't proven their case. There was a tricky one. Sanderson Farms was sort of on the edge of that conspiracy. Tyson and Pilgrim's Pride, which is JBS, had pled guilty to the DOJ for that. But Sanderson Farms was on the edge of that. And I think the feedback from those who got to speak with the jury was that, unfortunately, they just believed the CEO of Sanderson Farms when he got up there and said, I would never ever collude. And I think that what that shows is that jury trials are unpredictable, and that creates risks for both sides, not just the defendants and not just the plaintiffs. What has happened since is that the various cases still that were sitting behind that first trial have more or less settled. So I don't think we're going to see another broiler chickens trial. It's possible. There's also a Turkey antitrust suit that is also at class cert stage, so they're like us. Similarly, there are poultry wages suits, or red meat suits that the DOJ and civil plaintiffs have brought. It won't surprise you that the packers, in addition to fixing the price that they paid to the producers they bought their livestock from, were also getting together to fix the price that they paid their workers. So they would have meetings where all the high HR officials would get together and exchange information about what they were paying their plant workers and agree to keep it at low levels. So part of the reason when you hear them complain about not getting labor to run their plants is because they wouldn't pay them a decent wage. And they wouldn't pay them a decent wage because they agreed with each other not to, which I think tells you a lot about the way they do business. There was a peanut growers suit that ended quite well in about $250 million in settlements. There's also various crop input suits by the FTC and private plaintiffs regarding Syngenta and Corteva's loyalty programs, which are designed to prevent entry of generics. So it's a busy time in ag antitrust. I want to talk a little bit about the FTC and the DOJ, because I think it's a point that isn't often covered in the newspapers when people are talking about what the federal government does or doesn't do for you. So at the moment, the FTC is led by Lena Khan, and the DOJ is led by Jonathan Cantor. They were somewhat unusual picks for those agencies. Typically, people appoint people who come from defense firms, spent their life representing corporations, who are from the antitrust establishment. These two people are not. And what they have presided over is a significant uptick in aggressive enforcement by both agencies, both on the merger question, i.e. whether two companies should be allowed to merge, and on the conduct issue, i.e. is what a given company is doing anti-competitive. And I really want to talk about the merger issue first. They have been very aggressive in bringing cases to block mergers that previous FTCs and DOJs would have just rubber stamped. Now, they haven't won all of those challenges in court, but what their aggression has done is deterred companies from even pursuing mergers that they think is an edge case. And what that has prevented is a lot more consolidation in a wide variety of industries. And if you took a step back and thought about if this same approach to merger enforcement had been around in the 80s and 90s when the packing industry consolidated, would we be in this same predicament now? I think, and this is just my opinion, that we wouldn't be. And I think when you think about what your government is doing or not doing, one thing that both these agencies are developing is sort of bipartisan support from the senators and the representatives who care about antitrust enforcement. People like Senator Hawley on the Republican side or Klobuchar on the Democratic side are very focused on stronger rules for merger enforcement. And both of them, while they may not agree with everything they say about each other or what these people say, think that the FTC and the DOJ is doing a good job. And one way you know that it is working is that the people who represent the interests of the large investment banks and large private equity people who have the most to lose from strong merger enforcement hate them. The Wall Street Journal has run 100 op-eds attacking Lena Khan. Think about that. She has been in her position for less than 3 years. That's about one op-ed against her every 10 days. Now, I don't know about you, but if I'm not worried about somebody, I don't write an article about them every 10 days. You know? So I bring this up a bit like David brought up, you know, what you can do. And regardless of who you support in the upcoming presidential election, what I would encourage you when you speak to your representatives is to say that I like what the FTC and the DOJ has been doing in antitrust enforcement. Because there are representatives on both sides of the fence who like it too. And I think it's important as a public that we reinforce that we like our antitrust laws being enforced. We like it when companies can't buy every medical practice in Texas, bring it together, and then raise the price of basic medical care by 10%, 10 times, 20 times. We like it when the large sugar companies are not allowed to purchase each other, screw sugar farmers, and screw us by raising the price of sugar. These are things that we can all agree on. And I think the other great thing that this increase in merger enforcement does is that it brings to light antitrust conduct issues that otherwise wouldn't have come to light. And I'll give two examples of this. The FTC brought a case against a merger of two of the large sugar companies. I think it's American Sugar, and I forget the other one. They filed an agreement couldn't be reached between the merging parties how to solve the problem, so the FTC filed suit in Delaware, and they brought forward evidence that not only would in the FTC's opinion, the merger harm the competition for the inputs to make sugar in the southeast region of the country, and also the raise the price of sugar, they also brought forward evidence to the court that these sugar companies were actually already colluding. They were colluding through a middleman who provided market updates to all these sugar people, which were private, and they would tell this gentleman, this is what we're going to price for this upcoming quarter. What is so-and-so going to price? And he'd be like, hey, give me a moment, I'll find out. And he would email back, you know, your competitor is also going to price at that level and agrees to stay there. So basically that they were price fixing. Now, in what I think was a terrible opinion, the judge in Delaware said that that wasn't sufficient evidence of potential anti-competitive harm. And it got pushed up to the Third Circuit and they agreed. But what happened is, a bit like David said before about the fact that once the filings go on the docket and become public, is that private plaintiffs saw that and said, hey, that's a conspiracy. And what you have now is a series of very serious complaints filed against the sugar industry for colluding. So even though the FTC couldn't get the merger blocked, by bringing that bad conduct to light, there's now going to be civil enforcement actions by private plaintiffs. Whereas if they had just rubber stamped it to go through, it's likely that nobody would have ever heard of it. The second is the shale industry. Now, I'm sure this one has been in the news recently, so you might have heard about it. There has been a large attempt in recent years of larger shale producing companies like Pioneer to purchase smaller shale companies. And they're now also mergers. Exxon bought Pioneer, Chevron bought, oh Christ, somebody else. And the FTC has been investigating those. As part of its investigations into the Exxon Pioneer merger, in reviewing the documents that Pioneer had to produce, the FTC apparently found evidence that Scott Sheffield, who was Pioneer's former CEO, was actively colluding with other shale producers and OPEC to reduce their production of oil. And why, might you ask, would they reduce their production of oil? To keep the prices up, right? And if you think about the timeline of when this occurred, it occurred as prices were skyrocketing as we were coming out of COVID and as the Ukraine and Russia war was starting and oil prices were through the roof. Then here you had American companies, rather than be like, hey, price is up, I can pump more oil and make some more money, being like, actually, I can stop pumping oil and make even more money. And I'm going to check with my competitors to make sure they're doing the same. Now, Scott Sheffield has come out and said, no, 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 you've got it wrong. These are just my friends, exchanging basic information. But again, interestingly, my firm, before the FTC had done this, we had actually filed a suit alleging the same thing. Now, we weren't privy to the documents that the FTC had got, but we sort of pieced it together from public sources. We filed a suit alleging this in January. The FTC came out in May with its complaint against Scott Sheffield alleging the same thing. And that information is going to help us greatly in prosecuting that case to help have the shale producers pay back some of the money that you all were charged at the pump. So that's all to say, regardless of what you think or do not think the current federal government is doing right or wrong, I think one thing they're doing right is antitrust enforcement. And I would encourage you, when you're speaking to your representatives, to echo that fact. And again, I don't think this is not a partisan issue, it's a bipartisan issue, or it should be. Nobody wants antitrust problems. We all benefit from competition. And I think that is something that your representatives should all agree on. And so with that, I'll pause and take any questions folks have.
Hey, thank you, Patrick. And you know what? I can actually understand you better than 2 or 3 or 4 years ago. So your English is getting better.
I work hard at it. I have a tutor.
Hey, we come from Colorado, and we've got an attorney general. You excited me a little bit from what they can do to help you. And they have gone after Kroger. I don't know if some of you in our area, Kroger King Soopers wanted to buy out Albertsons Safeway. And they've become an active participant in slowing that down. But do they have enough staff? We sat there with Cargill, XL, and the cattle, and JBS. Do they have enough staff or resources to really look at the anti-competitive thing in the cattle deal? Could you expound on that?
Yeah, it's a great question. So I think it's fair to say that the feds have more resources than the state AGs. I don't think that the state AGs, and it's not a Colorado-specific issue, it's a sort of countrywide issue. The state AGs do not have an enormous budget to pursue antitrust actions, and some have more than others. And if I had my druthers, and remember, I can't vote, I would be encouraging states to allocate more resources to the antitrust divisions of my state Attorney's General office to pursue these. What the states are very good at, though, is coordinating amongst themselves to bring actions. So, for example, without revealing anything I can't, in the cattle investigation, the state AGs across all of the cattle producing states, red and blue, are cooperating together, and so they pool their resources. So they are very good at making do with what they have. They're really diligent, smart people who get up every day trying to make, an improvement for the people they serve. So I do believe, though, that they could do with more resources.